Good morning. Welcome to the Sycuan Gaming Commission Regulatory Fact-Finding Hearing. My name is Ed Magdaleno, and I'm the Director of Regulations. 20 years have passed since the United States Congress enacted the Indian Gaming Regulatory Act. While the statutory framework for Indian gaming has remained unchanged since 1988, IGRA has been supplemented and interpreted by numerous federal regulations and court decisions that have sought to keep pace with our rapidly evolving industry. This is particularly true in the area of Class II gaming, where both the regulatory environment and game technology has significantly changed over the last 20 years. To better understand the changes in Class II gaming that have occurred since IGRA, Sycuan is holding this regulatory fact-finding hearing to gather information on the history of Class II gaming, IGRA, pertinent case law, and the current state of gaming technology. We have invited many of you here today, including tribal leaders from prominent Class II gaming tribes, elected officials who have helped write IGRA, federal, state, and tribal gaming regulators, and others to participate and share your knowledge of Class II gaming. Before the hearing begins, I would like to provide a brief overview of the next 2.5 days. All oral testimony taken during the hearing will be recorded and transcribed. Each witness speaking before the commission will be allowed 15 minutes of oral testimony, followed by questions from the commissioners and commission staff. If testimony is being heard in a panel format from multiple witnesses, questions will be held until each panelist has provided their oral testimony. The Commission will continue to accept written testimony on Class II gaming until May 29, 2009. Details for submitting written testimony via email are located on our website at www.sycuan.com/hearing. For those of you interested in submitting additional written testimony during the course of the hearing, you may do so in the lobby of the administration building located next to the casino. Since the casino does not have wireless internet access, we have set up a business center in the lobby of the administration building as well. For your comfort and convenience, the nearest restrooms are located outside the theater to your right. Also, please remember to silence your cell phones and that no flash photography or no recording devices are allowed. Finally, we have provided light snacks and beverages for your enjoyment. As you saw when you entered, no food or beverages are allowed in the theater, so our refreshments are located to the left as you exit the back of the theater. Or if you may wish to visit one of our restaurants. Everyone at Sycuan wants to make your attendance a pleasurable one. Please ask any of our staff should you have any questions. Thank you. At this time, I would like to introduce Tribal Chairman Daniel Tucker to welcome you to this hearing.
Hi, Eddie.
How are you doing, sir?
Good. Good morning, everyone. Okay, I see y'all. How y'all doing today? Good, good, good. Okay. Well, thank you, Ed, and thanks everyone for coming today. On behalf of the entire tribe and our family of dedicated employees, welcome to Sycuan. At this time, I'd like to introduce a few of our tribal council leaders. Vice Chairman Mr. Ricky LeBrake in the audience. Ricky. Our Treasurer Cody Martinez. And I think Candy Billingsley, Pilar Pettiford, Orlando Sandoval, and Deidre Tucker should be around here somewhere. If they're not, they'll be here later. Okay, thanks. Indian gaming is unique. Tribal government is a gaming as intended by Congress with the passage of IGRA is a means of economic development for tribes. Indeed, it has been the greatest boom of tribal economies since the coming of the Europeans. Unlike commercial gaming, whose goal is profit, all of tribal gaming revenues are dedicated to supporting essential government services, including health, education, welfare, and cultural preservation, charitable contributions, and building strong tribal governments. We have complete confidence that every dollar generated by our casino is accounted for. The games offered to our guests are the highest integrity. We have this confidence because of the work of our Tribal Gaming Commission. Because of our Gaming Commission and the professional staff, the assets of our business are assured, as is the integrity of the games offered to our valued guests and our customers. The emergence of an independent Tribal Gaming Commission at Sycuan has strengthened our tribal government. Sycuan has been a leader in the development of gaming in California. Sycuan operates the oldest continuing operation to Class II gaming casino in California. And Sycuan was the first California tribe to establish a gaming commission. In fact, the oldest continuous serving gaming commissioner in California sits on the Sycuan Commission. While operating a successful casino has generated great benefits for our tribe, the most important thing to me personally about tribal gaming is the strengthening of tribal sovereignty. Through the exercise of this sovereignty, our tribal government is able to offer services to our tribal members that we could only dream of 20 years ago. We have effectively brought an end to decades of grinding poverty that existed here at Sycuan. Not only has tribal gaming benefited our people, but tribal gaming in San Diego County has generated tens of thousands of jobs in the surrounding communities. Tribal gaming has a significant stimulus effect on the economy of San Diego County. And I'm proud to say that the tribes of San Diego County, including ours, contribute millions of dollars to local charities each year. Our journey from poverty to prosperity because of tribal gaming is an American success story. Here at Sycuan, the Gaming Commission on a daily basis enforces the tribal ordinance that is part of our code of civil and regulatory laws. Each day that we enforce these laws, we are living our ancestors' dream of exercising as a sovereign nation. The emergence of strong tribal gaming commissions across Indian country was clearly the intention of Congress when they passed IGRA, the Indian Game Regulatory Act, 1988. We are very proud of our commissions, and they fulfill their missions by holding this important hearing. I tell you truly, without Class II gaming, our people would never have arrived at this promised land. It is critically important to Indian country in general, and the Sycuan Band is particularly that right of the Sycuan Gaming Commission to be the primary regulatory of Class II gaming and defended and preserved. My hope is for this hearing accurately reflects on the history and the intent of IGRA and shed the light of development of Class II regulations and technology, by preserving the clear intent and objective of IGRA, tribal oversight of Class II gaming. Thank you all for once again for coming today. And right now, I'd like to introduce our esteemed gaming commissioners. First of all, I need to tell you this, it's pretty important that we have an all-women gaming commission. And it's pretty cool because they're all women, they're all Native women. I can imagine how their meetings go. But also, what's really kind of unique is that they're all mother and daughter. So it's kind of a unique situation for that. So, that saying, I'd like to introduce first alternate commissioner, Ms. Charlene Eckel. Chairperson, Ms. Jackie Tucker. Commissioner, Quinette Pettiford. And unfortunately, our eldest, our commissioner who's been here the longest, Ms. Bernice Hyde. Bernice is ill today. It's unfortunate she can't be here, but she does send her love and appreciation for coming today, and she wants to make sure everybody knows that the success of this hearing is very important to her and this commission. So welcome to Sycuan, and have a great, great hearing, because it is important to all of us about Class II. So I turn this over back to Ed, or whoever's taking over from me, or Ms. Tucker.
Thank you, Chairman
Chairperson,
Tucker.
you're welcome.
This hearing will come to order. We will begin with roll call. Commissioner Pettiford.
Present.
Alternate Commissioner Eckel.
Present.
At this time, I would like to introduce the staff who will be assisting the commission during the hearing. Our Executive Director, Yvonne Atkins-Payne. Present. Our Director of Regulations, Ed Magdaleno. Tribal Attorney, George Foreman. Present. and hearing consultants Joe Valandra, Michael Lombardi,
Present.
Jess Green,
Present.
John Plata,
Present.
Joe Webster,
Present.
and Linda Mitrovich. Please rise for the prayer and blessing. The prayer and blessing will be given by Ron Chrisman, spiritual leader of the Ipai Nation of Santa Isabel.
Amen Pau. Mai kha matawai mataka khap yep ucham chuai. Ni pinyam pi yu khap ti kai limam mulu mau nyam pach miti pul nyam khmeo hiao mau. En you pum pia chuai ti pai a o hiao khan mau ti pai a chuai mau mo yao. En you pum ni pinyam mishish a chuai mulu mau pia chuai mam o yao uch wish mai. Grandfather, we asked you to come here and be with us this day, these series of days, as we listen and try to learn, try to make good decisions for the benefit of all our people, but not only our people, Grandfather, but also all those many different peoples from around the world that we impact. We ask, Grandfather, that you look after our families back home, for they are unable to be here with us and wonder and worry about us as we travel, many of us, a long distance to come here. We ask that good health and happiness and strength be given to them while we're here, grandfathers, that we do not have to worry about them. We ask you to look after our elderly and ask to hear our prayers for our ancestors that brought us to this point in time, gave us the strength and knowledge and the wisdom and forbearance to try to do the job that we're doing in a good way. We ask you to look after this band of my people, Grandfather, for they have succeeded where no one thought, in a manner that no one thought possible many years ago. And now they help not only the other bands here, but they also help the surrounding community. This is part of our traditional way, Grandfather. We ask that you hear our prayer of thanks for allowing this to happen. We ask for strength and wisdom for this commission that's here and all the questions that will be brought before them, and ask that you help them and be with them as any decisions that are made. We thank you, Grandfather, that you've allowed us to be the way we are. We thank you for the wisdom of these people that have come here. We ask that you impart even more to them, that they can do their job as well as possible. When pau nyami pachmiti pul kwai nyam khameo hiao mau nyam pumpi wiyu hap tikai elimam pia chwe kio kaprsho mulu mau pi khamei wiyu hap kur mam mawai khan moyao kam kio kaprsho chwa mushmai hi.
Thank you, Mr. Chrisman. Prior to calling the first witness, the commissioners will present their opening statements. We will begin with alternate Commissioner Eckel.
Good morning. It is good to be here today. As the newest commissioner of the Gaming Commission, I look forward to the testimony that will be presented. I began working at the commission as a file clerk through the tribal training program. I worked through several positions before I was appointed to serve as alternate commissioner. As a new commissioner, I have dedicated myself to studying the various facets of my duties. I view this hearing as an opportunity for me and my generation to become knowledgeable of the actions and history that enabled Indian gaming to grow from playing bingo into a $26 billion industry. We need this knowledge, as will future generations. I'm here to listen, learn, and to be educated. I am humbled to have this opportunity to sit at the feet of the men and women who built Indian gaming over the last 20 years. The knowledge and wisdom I gain here will enable me to effectively execute my duties and responsibilities as a Sycuan Gaming Commissioner. I look forward to hearing the testimony that will be presented over the next 3 days. Thank you.
Thank you, Commissioner Eckel. Commissioner Pettiford.
Alka, good morning. I'm grateful for the opportunity to serve on this commission and be part of this historic hearing. From my grandmother and my mother, I've learned the value of serving my tribe. Listening to them and other tribal leaders, I also learned about the years of struggle to build Sycuan Casino. In an attempt to honor these teachings, I started out as a clerk at the Gaming Commission. I've had the opportunity to learn what the commission does from the ground up. And as a commissioner, I continue to learn as much as I can about Indian gaming and regulation. I've taken the National Indian Gaming Association's commissioner certification twice, and I've attended numerous conferences and panels to learn everything I can about tribal regulation. It's with great anticipation that I look forward to hearing from the array of experts who will be testifying before us. This experience will add to my competence as a tribal gaming commissioner. This record will lead to a better understanding of history, current issues, and the evolution of technology, which will enable us to make knowledgeable and informed decisions that will impact future generations, not only for my Kumeyaay people, but for all tribal nations. Ohei, thank you.
Thank you, Commissioner Pettiford. Class II gaming is as important to the Sycuan gaming enterprise today as it was 20 years ago. Indeed, across the country, it is generating billions of dollars for our tribal governments. Because of the breathtaking pace in electronic computer technology, the face of Class II gaming has changed enormously over the last 20 years. As Class II gaming continues to evolve, tribal gaming commissions are obligated to keep up with the latest information. As you all know, this is a daunting task, given the ever-changing landscape of federal regulation in this area, as well as the efforts by some states to intervene in the regulation of Class II gaming. This, coupled with the never-ending parade of new technologies and games developed by our vendors, requires knowledgeable, educated, well-informed tribal gaming commissions. Over the next several days, the Sycuan Gaming Commission will endeavor to collect relevant historical information, as well as educate ourselves about the latest developments and issues in the regulation and operation of Class II games. Much of our success is a result of battles fought and victories won by tribal governments in other regions of this great country. We recognize and honor the enormous contributions to the advancement of Class II gaming by tribes in Florida, Montana, and Oklahoma. Their leadership and wisdom have forged the ways for tribes like Sycuan. We take this opportunity to recognize and honor their invaluable contribution. During the course of this hearing, the SGC will actively seek to learn from their experiences and successes. We appreciate the opportunity to hear from some of the earliest practitioners of the art of Class II gaming. Upon the conclusion of this regulatory fact-finding hearing, it is the intention of the Commission to collect all of the valuable information that will be provided by the witnesses, as well as through submittal of written information. We intend to take this information and compile it for educational use for ourselves and our successors. It is our hope that this information will aid our Commission and other tribal gaming commissions in making the difficult decisions that lie ahead. Let me make it perfectly clear. The purpose of this hearing is information gathering to establish the historical record of Class II gaming, not only for today, but future generations. Let me share with you about the hearing itself, how it's been organized, and what you can expect over the next 3 days. We have representatives attending from tribal, federal, and state governments, including the California Gambling Control Commission, Bureau of Gambling Control, and National Indian Gaming Commission. On behalf of the Sycuan Band, you are most welcome here today. I am particularly pleased to have here today the chairman of the largest Indian Gaming Association in America. Let me take a moment to personally congratulate Chairman Ernie Stevens, Jr. on his re-election to an unprecedented 4th term as chairman of the National Indian Gaming Association. You should have all received materials when you came into the theater, including an agenda. If not, please see someone from our staff. Today, we will begin with individual witnesses and then have two panels. The first will be tribal leaders, and then we'll be hearing about the history of IGRA. Thursday and Friday, we will have panels discussing the history of bingo, independent testing labs, and Class II vendors. We will have the federal perspective and then a panel comprised of tribal regulators. We will also hear from a panel of attorneys on history of Class II litigation. Panelists will have 15 minutes for their testimony, and there will be opportunity for questions and discussions following each panel. In the interest of time, the Commission will not entertain testimony from the audience. If you do have information you would like to share, we are accepting written testimony until May 29th. The testimony given at this hearing is freely given and is not meant to subject any party to the jurisdiction of the Commission. Before we continue, let me remind you to silence all cell phones and electronics. Please be aware that no photographs are allowed, nor are food or beverages besides water allowed in the theater. An enormous amount of resources have been devoted to this hearing. I would like to thank the Sycuan Business Committee, our commissioners, and all the hardworking staff who have endeavored to make the hearing a meaningful occasion for everyone attending. We are all excited to be here, so let's get started. Our first witnesses will be testifying as individuals. Mr. Ernie Stevens, Jr., Chairman of the National Indian Gaming Association, please come forward.
Thank you, Madam Chairman. Thought I would be a little relaxed, but I guess I'm a little nervous. I've testified before Senate, Congress on many occasions, and I don't know if I was more nervous now or then, but I think that the magnitude of the responsibility that exists here is what may make me just a tad bit nervous, in spite of my numerous testimonies that I've given over the years. So, again, I wanted to thank the Sycuan, the leadership on behalf of the tribe, and the commission here for conducting this hearing. I think it has a nationwide rippling effect that continues to strengthen an already very strong regulation process throughout Indian country. I stand before you today, thank you, continue to build upon our regulation throughout Indian country. As chairman of the National Indian Gaming Association, I appreciate the opportunity to offer my views on the subject of regulation of Class II gaming to the Sycuan Gaming Commission. This government hearing is on the subject of recently enacted Class II technical standards by the NIGC, an issue of vital importance to the entire American gaming industry. Congress intended that tribes could utilize existing and future technology to enhance Class II gaming, to expand player participation, and thus increase the economic benefits to tribes in the operation of Class II games. If I could pause just a minute, Madam Chair, to my little advertisement about the impact of Class II gaming. There are so many tribes, for good and bad reasons, that are dependent upon this industry, and that's why we take it so serious in Indian country. Without these games, we would be taking backward steps towards poverty. In addition to that, we also recognize that there's many tribes that can utilize this to continue to build tribes away from some of the economic struggles we had over decades. So I wanted to just, as I speak to this issue, I want to just help people to understand and appreciate the seriousness of the magnitude of this responsibility related to Class II games. With the passage of the Indian Gaming Regulatory Act in 1988, Congress also intended that the regulation of Class II gaming would be regulated exclusively by tribes with some oversight by the NIGC. The emergence of strong, effective, and professional tribal gaming commissions has been a vital element in the growth and the development of Indian gaming, and this is a national trend. I got to figure out how to say it, so I'll pause again, Madam Chair Lady, that this national trend of regulators is, I don't want to take anything from this body here, especially since you've just been recognized by the National Indian Gaming Association for your leadership in regulation. but this is something that it resonates throughout Indian country. There's so many people like you. Now, I don't know if there's an all-woman woman commission out there. We'll have to check that one. But we do have a lot of women leaders throughout Indian country. That's just the way that God taught us. But the important factor that I like to make is that we have a tremendous influence by the leadership on the regulatory side. And you guys are one great example of holding strong for tribes throughout this country. And I'm honored to stand here, sit here and testify. I think it's important to understand that through education, training, and our experience, that we are more and more becoming the experts of this industry. Now, granted, we used to take a few folks, maybe some retirees from the IRS, FBI. I mean, yeah, we brought them over to our side, and they helped us learn about this. Because, again, integrity. But now the more recent trend that you'll see is that we are the experts. You guys are the experts. Education, training, experience, we have evolved into the experts. And we still have folks, young people going to college, and they want to work in gaming. On Friday, my youngest daughter graduates from college. So a little plug there, I'm sorry. The Haskell Indian Nations University. And then we will honor on Thursday night a gaming class that has been going on. These people, before they would say, do you want to go to college to what? To play bingo? You're going to take what? Bingo 101? You know? Now, in colleges all over this country, they understand the management, the marketing, the regulation, the priority. And in Indian country, this has always been our priority. But now, through education, we're becoming the experts. So we'll celebrate that this week. Sorry, a little personal plug for what I think is one of the better colleges in the history of the United States, the Haskell Indian Nations University. But their gaming class, we're very proud of, Madam Chair Lady. But I guess, you know, and I get into my advertisement there, and I kind of lose track of my point. I think Commissioner Bedford said that you've taken our training twice at NIGA. Well, again, maybe another selfish plug for our training at NIGA. But the training is done by us. I suspect that the Commissioner could be one of our teachers in the near future. You know, because I think what the experience that we have is, that's why we're good. And I'm not bragging, and maybe I should be a little more humble. But the reason we're good is because our people are in those classes. They're living it, they're learning it, and they're teaching it all together. And I think that's the reflection, and that's the excitement of taking it twice. I think because you can, if you take it a third and fourth time, you'll probably learn some more then. And so I think that's something that we're very proud of, and I think that's what makes us the experts. And so while the growth of Indian gaming to a $26 billion industry has captured the attention of the entire nation, the emergence of a strong tribal government regulatory system is an accomplishment tribal leaders must be proud of and continue to make our #1 priority, the integrity of the games. This is not a new priority. Indians have games since long before 1988, and yes, it was always about integrity. And I think that you, especially in this close-knit community here, understand that long before we have to worry about government officials, the IRS, the NIGC, we have to be accountable to our communities. And I think that's what's held us to a higher standard, and we're very proud of that. And I think that, you know, if I could digress just for a minute, Madam Chair, but remember the old days when we used to have to fight to prove our point? People didn't even know who we are. They didn't even understand what we were doing, yet they would take positions that were against our position, our regulation and the things we were doing without even checking their facts. Mr. Bill O'Reilly did that in what he calls the no spin zone once. He made that mistake once. And we went in and we lobbied and we talked to him, and I took him nose to nose, and I told him about the regulation. Well, he's never picked on us since. And he's never put us in the no spin zone because he understands, I think, that we don't spin. We're direct, we're straightforward, and we're accountable. And so a couple other high-profile professors have had some issues with us. I forgot their names, don't come to me just off the top of my head. But then, even those people, you know, we still got a little ways to go, but even those people were still proving points to them. And I think our good friend, Governor Schwarzenegger, has learned to appreciate the work of tribal leadership. And I commend the leadership because it wasn't always that way. It's taken a lot of long hours by the California tribal leaders, a lot of patience on both parts to work with the state of California and the governor, and I think we've come a long way. I say this, I like this term, we've come a long way, baby. You know, it's changed, but we're nowhere near what we have to be, and that's why it's important that we stand here to document our work and move forward. As a result of tribal gaming innovations, Indian gaming has become the most innovative and advanced form of gaming in the world. Advances in the application of digital technology to Class II and Class III gaming have revolutionized the gaming industry worldwide, not just in Indian country. Yet for some reason, we always have to defend our right under Class II even more. And you know what? We're proud to do so. We're used to that. We're used to the higher standard. And again, it doesn't start with repetitiveness on behalf of the outside world. It starts within our own community. They're the ones that keep us at a higher level and make us perform at a higher level of integrity. That's something we have to do just to go out the door right at home in the reservation. And you know what? That's okay, because I think that we're all used to working harder. I don't know about any of you folks, but I think that your elders hold you to a higher standard. And that's just the way it is in Indian country. And we think we have a powerful, professional, consistent track record, and that's why we can stand before all of you and be proud today. When we look at the advances in Class II industry, it is astounding. Application of computer technologies to bingo. The use of internet, telephone, and satellite technology to link together thousands of players at hundreds of locations. 8-liner, 9-liner, multi-play slots, touchscreens, and cashless wagering tickets are all Indian gaming-driven enhancements first seen in Indian casinos. It makes me proud, and it gives me energy. And as we stand here today and listen to this historic testimony, let us all remember that there is nothing more important than protecting the primacy of Indian regulators as the day-to-day watchdogs of Class II gaming. And congratulations to Indian country, to you. We have done this. We have nailed this. But you know what? I know that, Chairwoman Tucker, I know that you'll be the first to tell your colleagues, we don't rest. You never know what's happening out there. And in order for us to continue to be the best, we have to be hard at it on the front line. And I think that's what this is about today. It's not that we are doing it. It's not that we are doing it. It's that we finally are receiving appropriate recognition for it. Not just here today, but nationally as well. I just, again, want to say congratulations to the Sycuan Nation and their Gaming Commission, the first in California, for taking on this important challenge in advancing the effective regulation of Indian gaming nationwide. This is a national level hearing, a product that will resonate throughout Indian country. I could say that one more time. I'm so proud of you, and I just, from Washington, D.C., we say keep up the good work and keep working hard, because there's a lot of folks out there that are doing what you're doing. There's a lot of folks out there still learning to do what you're doing. And right here, right now, is where we can resonate that energy. So to that end, I wanted to conclude my testimony here today and comments to tell you that to remind this body that the National Indian Gaming Association at its annual meeting in Phoenix in April adopted a resolution supporting this hearing. The Phoenix 09 resolution specifically recognizes this historic hearing on tribal regulation. This resolution passed unanimously by the National Indian Gaming Association's 180 member tribes. I just want to just say this one more time, and maybe I just like hearing it, but the fact that we could walk the walk in Indian country, staunch regulation, checks and balances, high-tech security. America, welcome to our world. That's Indian gaming. In my final conclusion, Madam Chair, I would like to mention that reiterate the national recognition that you folks receive gives you puts you in a role of providing for people who will look to you for leadership. And so again, this hearing, I think, is a reflection of that. I think that it's important that we continue to work together, continue to help one another. I know we wouldn't have knocked down the roadblocks that we've knocked down. And, I could spend We could spend 2 days talking about all the obstacles, all the roadblocks, and all the relationships that we built. But today, I understand, the next 2 days, we have an important responsibility, and I'm excited to be a part of that. For today, I apologize, Madam Chair. As I said, I will return to Lawrence, Kansas to be with my daughter for her graduation. And tomorrow night, we will host our reception honoring the Indian Gaming class graduates. So again, in my conclusion today, I would just say congratulations to all of you for the work you've done here at Sycuan. Continue to help us as we build this, continue to build upon our regulation efforts throughout this country. But I'm just, I don't know if you can detect it. Maybe I'm not so nervous anymore as I am excited. And now I don't want to stop. Couldn't get me started. Now I don't want to stop. So you need one of those red lights and just hit, again, so it's not on yet. I can keep going. No, I think that I've said enough, and I think that you have done enough here at Sycuan, and I'll do anything I can to do what I can to enhance the regulation endeavors here at Sycuan. And while I brag about all the commissions nationwide, today is unique. Today is special. Today is historic. I don't want to take anything from that, and I look forward to you folks. You can help us teach this class at the National Indian Gaming Association training in the near future. So to that extent, that would be my comments for today, Madam Chair.
Thank you. Are there any questions for Chairman Stevens? Okay, thank you so much, Chairman.
Okay, great. Let me off the hook. All right. Thank you.
Mr. Anthony Miranda, Chairman of the California Nations Indian Gaming Association, please come forward. Good morning.
Chairman Stevens is always a hard act to follow. Good morning, Madam Chair and members of the Commission. Thank you for the opportunity to speak before you today. On behalf of the California Nations Indian Gaming Association, we would like to recognize the Sycuan Gaming Commission for its foresight and vision in holding this hearing. It has been over 20 years since Congress enacted the Indian Gaming Regulatory Act. A long struggle. Many of those in this room were leaders in this battle, including your own tribal chairman, Danny Tucker. I was just a young guy when I came on the scene with Danny and all the tribal leaders, and we've come a long way. And what have we learned over the last 20 years? We've learned a few things. And I'm proud to say that this great state of California, we've been innovators in this state. A lot of historic things that have happened in Indian country have happened in California. And we've learned that through strong regulation, we can protect our industry. We've also learned that Class II gaming has been an integral part of the growth that we've experienced here in this great state of California. It's something that we started in the beginning. It's helped us grow. We've grown this industry in the state of California to there's a lot of different numbers floating out there, but I think I'm safe to say I think it's about $5 to $6 billion industry here in the state of California. Almost a third of the average of the national average is generated here within the state. And Class II has been an integral part of that. I've seen us grow from cartridge machines to pull tab machines to the electronic versions of that you have right now. And what I've learned is that Class II gaming has been a bastion of sovereignty for the tribes in this state, and I think for all the tribes across the United States, and it's something that we must protect, and that we must protect as we go forward, because it's something that we can regulate without a compact within IGRA. And as you see that the states applying more and more pressure on tribes to generate revenues for their coffers, and looking to tribes to do that, that Class II is the one thing that we can rely on, that we can use that is exempt from this. And I think that we need to protect that. We've seen innovations happen in California, 8 lines, cashless gaming's happened in California, and we've also developed, I remember when we developed a roadmap for the development of Class 2 gaming and taking that to the National Indian Gaming Commission, and that was done with some tribes here within the state, and the state of Florida and the state of Oklahoma, that we've developed that. We took that to the National Indian Gaming Commission, and we've actually developed a roadmap that manufacturers can actually look to on how to develop a Class 2 game. And then once we did that, you've seen an explosion of the industry being developed and innovations happening in the industry within the state of California, and then also within other states. I think what you're going to be seeing within the state of California, you're going to be seeing a more proliferation of Class 2 gaming within the state. I think that the Governor Schwarzenegger, you know, every tribe has the ability to negotiate their own compacts within the state, but the state is looking more and more to generate revenues for its coffers, and Class 2 gaming has been exempt from that, and I think tribes are looking to develop more and more within this arena. So I think that we need to protect it. I think this is a great hearing to have, and taking a look at the history of Class 2 gaming that's been developed within the last 20 years of IGRA, and I think it's something that must be protected and maintained, and it'll help strengthen tribal sovereignty as we develop and go forward. And also, what I'd like to say in conclusion, and this is I think this is a warning signal, and we're hearing it just as a whisper, but I think it's going to become louder and louder as we move forward. Class 2 gaming, remember, folks, Class 2 gaming only exists within Indian country. It doesn't exist anywhere else. But I keep hearing whispers that Class 2 gaming exists in other areas, and it doesn't. But you keep hearing that, and I think that's something that we have to maintain, we have to watch, and we have to protect it within Indian country. So, in conclusion, I think it's a great thing having this hearing and taking a look at that, and also maintaining Class 2 gaming within the confines of Indian country, because it doesn't exist anywhere else, and we have to be careful of that as we move forward. So thank you very much for the opportunity to have testimony, and I appreciate that, and would gladly answer any questions that your panel may have on the history of Class 2 gaming, or taking a look at Class 2 gaming within the state of California as we move forward.
Are there any questions?
Madam Chair, I have a question. Michael Lombardi, it's great to see you, Chairman Miranda. Could you expand just on a moment your earlier comments? As you know, there have been controversy associated with the Class 3 device license pool.
Mm-hmm.
It's as dry as the Owens Lake. That, of course, in my opinion, has driven a number of tribes to utilize Class 2 technology. To what extent do you think that dynamic and the recent compacts that extract large percentages of our net revenues, which most tribes can't afford, have driven tribes to use or examine or think about Class 2 games as an alternative?
Correct. In taking a look at your first question, Michael, it's a very good question. Within the state of California, when we first negotiated the 1999 compacts, we thought, and maybe naively, that there was more than enough licenses for machines for whatever tribe to develop that they could put in for their operations up to the limit of 2,000. And when I say naively, because if you look at the compacts, literally they read that every compact, every tribe could develop 2,000 games or go up to 2,000 games. However, the state took over the licensing process. And once the state took over the licensing process and issuance of those licenses, then they issued a what we felt was an arbitrary cap on the number of licenses. So then tribes that wanted to develop 2,000 games, or maybe their market had not developed or had not matured enough at that time. So in 2000, maybe they were operating 1,500 games, but their markets had not matured to where they could operate 2,000 games. But in 2009, the markets had matured where they could probably put in up to 2,000 games. They've been unable to. So this left tribes with a couple of things. They could either sue the state in terms of getting more licenses, which some tribes had done, and now they're starting to get a little bit more traction in those lawsuits. And there's some tribes that are starting to actually make some headway in that and winning some of the lawsuits. Or they could put in Class II games. And at that time in 2000, the market had not matured. The Class II market had not matured to where you may not have had a viable product. However, certainly as the market had matured and you had innovations within Class II product design and innovation, certainly Class II games had become a viable market in revenue generation for the tribes. However, that is not to say that they would compare with the Class III machine, because certainly in my experience, a Class II game certainly has not developed the revenue of a Class III game, which actually could be the demarcation line that Chairman Hogan has been looking for, when he's been trying to develop that with his regulations. However, so they've been able to do that. And then taking a look at some of the compacts that tribes have negotiated, certainly there's some tribes that can operate unlimited Class III games, but they haven't. And some tribes can operate up to 7,500 games, and some tribes up to 5,500 games, but they haven't. Why? There's been a couple of reasons. You may look at economic conditions. The compacts that were negotiated were negotiated in 2005, which, if you take a look at the history of gaming within California, that was at the high point before we started hitting the economic downturn of 08 and certainly 09. However, even in 06 and 07, tribes didn't expand because the markets hadn't matured to take those games. And also, the economic strain of having to pay additional revenues to the state for those games wasn't viable for tribes, where they wouldn't been able to expand because the revenue that they would have to pay for the state was too high to pay for, where the Class III game was no longer profitable for tribes to put into their facilities because of the revenues that they would have to pay for the state. So then that left them the choice of actually putting in Class II games. And what you're seeing some tribes doing now, some tribes that have negotiated those compacts are taking a look and saying, hey, look, we may have to pay, in some cases, $75, $85 a day to the state to add an additional machine. And this may not be as profitable as putting in a Class II game to where we don't have to pay anything to the state and put these machines, these games in and generate profits for our governments and for our people, which is really what tribal government gaming has been about, was to develop revenues that tribal governments can actually depend on for their people. Because certainly you know, these are not a for-profit, private enterprise types of industry. You know, we have to pay for healthcare. We have to pay for retirement programs. We have to pay for educational programs. We have to pay for infrastructure. We have to pay for all of these government services that private casino gaming does not have to pay for, you know. So that is the major difference in terms of tribal government gaming and for-profit casino gaming. And we have to be very cognizant in taking a look at what we have to put in that can generate revenues for our own tribal governments, and what is more profitable in doing so than not.
Thank you.
So, thank you.
Any other questions?
Yes. Chairman Miranda, first of all, thank you very much for coming here today, and thank you for your years of leadership at CNIGA. Brought that organization a long way in very difficult times. I just have a few questions. First of all, how many tribes currently belong to CNIGA?
Currently, I think we have close to 40 tribes.
And of those, how many operate casinos?
It's right around half. We're up at about 50% of our membership are into gaming, and about 50% are not.
And of those, how many operate Class II games, if you know?
You know, I don't know. That's a very good question. I would say maybe 25% might be operating Class II. More and more are looking into it, into putting in more Class II games. Some tribes, their markets have matured. They're not able to expand because of the number of licenses. They're in the Class II, the license issue that Michael had just mentioned. They can't get more licenses, but the markets have matured for them, and they want to add more games, more profit. We have some tribes have negotiated compacts, renegotiated the compacts, but it's not as profitable for them to add games, and then they're looking for Class II, the Class II machines to be put in those, the Class II games to be put in.
Thank you.
Sure. So it's
Any
a mixed
other
bag.
questions? Mr. Belandra?
Thank you. Hi, Anthony. I just have one question. It's a little bit broad, but you've touched on it tangentially when you began talking about revenues and the definitions of games. And I would say one of the issues that we seem to be confronting is that definitional issue. Touched on Chairman Hogan's efforts to create what he called the bright line. We've been confronted with different viewpoints from the state of California on what is and what isn't a Class II device. From your perspective and from your experience, what guidance would you give the Sycuan Gaming Commission as they look at future definitions, changing definitions of what is or what isn't a Class II game, both from the point of view of revenue generation, as maybe you pointed on, and sort of some of the technical aspects of that, from your members' point of view and certainly from your vast experience?
Well, in my experience of taking a look at Class II games, just operationally, just as an operator, the player knows the difference between a Class II game and a Class III game. The machine player is very intuitive in terms of the games that they play. And just operationally, and putting in a Class II game versus a Class III game, the Class II game has never, and I'm not here to berate that industry, because I think there's been a lot of innovative changes within the Class II industry, but we've never been able to see that a Class II game has developed or maintained the same revenue as a Class III game. So just in terms of operationally and taking a look at it, you already have an operational demarcation in terms of the revenues that are generated. In terms of looking at so taking a look at that, if you have to pay revenues to the state, that demarcation line comes up, but it's not done. It's kind of done artificially, because of the fees that you would have to pay for a Class 3 game, you know, that kind of narrows the gap between what a Class 3 game would make and what a Class 2 game would make. But that's not done by the operations of that type of game. That's done arbitrarily by the fees that you would have to pay that have been negotiated to the state. So,
Anthony,
yes.
if I might, I'm sorry to interrupt you, but it made me think of something there when you talk about that difference. You know, one of the efforts by the National Indian Gaming Commission has been to dictate how the game is played by the number of touches, how fast it can play, which really impacts on the revenue numbers that I think you're referring to. Is that sort of also what you have in mind when you're talking about the difference in revenue levels?
Yeah.
How the game's played?
That's maybe I've been in this business for too long, but I've seen when we first rolled out Class 2 games in as being an operator in the year 2000, myself or took a look at Pechanga facility and other facilities where we had already operated 2,000 games. We had taken a look at the market, and our markets maintained that we could actually develop more games or have more games than 2,000, or there was an opportunity to generate more revenues from our market than what 2,000 games could generate for us. So ourselves and other facilities took a look at the Class 2 games, and we brought in the one-touch game, which generated a fairly sizable amount of revenue. However, you still didn't see the revenue generation of a Class 3 game. Then when the National Indian Gaming Commission rolled out the different versions of what they considered were Class 2 games, and in the compliance of those versions, you saw the revenue streams that these Class 2 games diminish almost by 25 to 50% by complying with the National Indian Gaming Commission. So it seemed like to us that the goal of the National Indian Gaming Commission wasn't to enhance the Class 2 industry, but the goal of the Gaming Commission on a national level was to kill it. Because every version that they came out with, you got one-touch version, then they had two-touch version, then we're looking at the three-touch version. But every time we tried to comply with those, we saw our revenues drop off significantly in trying to comply with the National Indian Gaming Commission. So so that was one of our arguments, that operationally you already had a demarcation line just in terms of the revenues that they generated from Class 2 to Class 3, because they never ever compared with what a Class 3 device was making in the state of California. Now, that might be different to other states, but certainly in the state of California, we never saw, to my experience, that a Class 2 game generated the same amount of revenue as a Class 3 game. Just wasn't there. I hope that answered your question.
Any other questions?
I think there's one in the back. Joel?
Madam Chair. Chairman Miranda, just to follow up on a point you made a minute ago in terms of the demarcation between Class 2 and Class 3. Obviously, one of the arguments that's been made by the National Indian Gaming Commission is the need for what they consider a bright line or brighter line between Class 2 and Class 3, that somehow there's a inability to tell the difference between a Class 2 game and a Class 3 game. Based upon your experience with Class 2 gaming, in fact, have both operators and tribes been able to tell the difference between Class 2 and Class 3? And can you give us some examples maybe of the differences that you've seen? I mean, obviously revenue is one aspect, but maybe other aspects of that experience.
Well, not to sound crude, but butts in the seats is another difference. if you would take a look on a Monday through Wednesday, if you look at a floor where you would have a mixture of Class 3 games and Class 2 games, you would see that the Class 3 games would have more players sitting in those types of games, and that you would not see the Class 2 games fill up until you hit the weekend or your optimum rate of play, which would be on your Thursday afternoon, Friday, Saturday, and then start to diminish Sunday through Monday, to where the flow of your customers would flow from the Class 2 games to the Class 3 games, because all the Class 3 games were taken, and then they had overflow onto the Class 2 games. So just taking a look at that. So from an operator standpoint, we saw all of this operationally. We tried to make that known to the National Indian Gaming Commission as best we could, but still they wanted to create that demarcation line. And that was something that we never understood, because you already had the demarcation, the bright line, was already built into the way the game was played. B, the revenues that the game generated was already built into the system. So you already had it there. Just never could understand the thinking from the National Indian Gaming Commission.
So
level.
I guess what you're saying is, at least from your perspective, there already is a bright line. There's not a need for some additional line to be imposed.
Operationally, we never saw the need to impose that. It was always something that Chairman Hogan had always said there needed to be, but we saw that through our own customers playing the game, playing more Class 3 versus Class 2, unless the Class 3 games were full. Then they would overflow into the Class 2 facilities.
Okay, thank you.
Any other questions? Thank you, Chairman Miranda.
Thank you very much, Madam Chair, and thank you very much for the hearings. Appreciate it. Thank you.
I would like to call the next witness, Mr. Jacob Applesmith, Director of the California Bureau of Gambling Control.
Good morning.
Good morning.
Thank you, Chairperson Tucker. Thank you, Commissioners, for having me here. I am representing the Attorney General, Jerry Brown, who could not be here today. He was here last night on the reservation, however, and was very glad to talk to a lot of you about many of the issues I'll be addressing here today. In the Department of Justice, which is under the purview of the California Attorney General, is the Bureau of Gambling Control, which I am the director of. The Bureau is essentially the on-the-ground regulator for the state of California for both tribal casinos and for card rooms. There are 91 card rooms in the state, and there are approximately 60 or 61 tribal casinos today. We do not regulate Class 2 gaming. That is in the purview of tribal governments and the federal government. So what I'd like to talk about briefly today is somewhat of the evolution of the state of California's role in regulating gambling in the state, and then to talk about the Bureau specifically, as well as the Attorney General's role, and then I'd be happy to answer any questions that you have. I will be very brief on the history of gambling in California because you all know it a lot better than I do, and there are going to be some people up here who are truly experts. But let me say that I'm very pleased that you're creating an historic record today. I think that's something that Americans have not been very good at over the years, and that you're actually taking oaths, or not oaths, but it feels like I'm taking an oath, And recording this, I think, is truly wonderful. So I commend you, and I commend the Sycuan people as well for investing in this. In the late 1970s, of course, bingo became a very important business for tribal governments, for tribal people. In the 1980s, the state of California really did not have any type of organized regulation of gambling in the state. It was largely left to localities, counties, and cities. In the mid-1980s, the state of California enacted the Gambling Registration Act, which applied only to card rooms at the time, but it was really not an effective system in any sort of way. Also in the 1980s, there became a quite uneasy relationship, let's say, between California governments and tribal governments over the regulation of bingo on tribal lands. And that led to the Cabazon decision, in which the United States Supreme Court, of course, ruled that tribal governments had the same rights to conduct gaming on tribal lands that existed in the states where those tribal lands were, and that the states did not have the ability to regulate that gaming because of the sovereign status of tribes, as well as the complicated regulatory and treaty structure of the United States and tribal governments. Cabazon led in large part to the Indian Gaming Regulatory Act in 1988, and through the Indian Gaming Regulatory Act, modern tribal gaming, Class 3 gaming, at least in California, came into existence with the compacts in 1999 and with the Constitutional Amendment 1A, Proposition 1A, which allowed tribal governments to have Class 3 gaming on tribal lands. The Bureau of Gambling Control within the Department of Justice was created in 1998 by statute, the Gambling Control Act, which largely applies to card rooms, but is also part of the gambling regulation for tribes in the sense that the compacts themselves refer to the state's role in regulation as that defined by the Gambling Control Act. Under the Gambling Control Act, there is the Bureau of Gambling Control, and there's the Gambling Control Commission, one of which is largely a regulatory body. The Gambling Control Commission passes our regulations. It's involved directly with the tribes in terms of counting slot machines and counting revenues. And then there's the Bureau of Gambling Control, which is involved with the licensing, quote-unquote licensing. It's really technically a finding of suitability for key tribal employees and for the vendors of two Indian casinos. Really, the Bureau of Gambling Control grew during the past decade to what it is now. We have 50 peace officers, special agents who enforce criminal laws related to gambling in tribal casinos as well as card rooms. And we have another approximately 120 people who are involved in licensing of employees, vendors, and on the card rooms of the people who own the card rooms. This has been a fantastic partnership with the industry in the state of California. A tribal leader told me recently that he viewed sovereignty as not only a right, but a responsibility for tribes. And as I thought about that, I thought that is really exactly what it is for the state of California. It's a responsibility to the people of California and to other governments, such as tribal governments. And that really has been the philosophy of the Bureau and how we regulate and how we relate to tribal governments. You are the first-line regulators, the primary regulators of your gaming industry. You're there to make sure that the games are honest, that they're fair, and that the tribal casino operates as a proper, appropriately run business, and that your people are served and that your customers are served. And our experience with tribal governments and the regulators has been phenomenally successful in my view. It has been a wonderful partnership. Wherever I go and meet with tribal gaming commissions, they know our agents and our field representatives, and they have good relationships with them. We are basically in this for exactly the same reason, which to ensure the honesty and integrity and safety of tribal casinos, so that people in California can be confident that when they come here to play, they'll be treated fairly, they'll be safe, they'll understand what they're doing, and they'll be welcomed. And that has been our experience with tribal casinos. And I just want to commend Sycuan, because you have a fantastic gaming commission, and I'm not just saying that because you're sitting in front of me, but it's true. You have a great surveillance system, you have a great security system. I mean, it's truly been just a fantastic relationship in our view, and that has been true throughout the tribes, with tribes throughout the state of California. California should be very confident that your casinos are run as well as any in the entire world. And that truly is something that we should all be proud of, and certainly the Bureau is proud of. We also believe that it's an evolving relationship, and we want to keep working with you to figure out how we can best be partners and how we can serve the people of California and our mutual interests in that regard. So I'd be happy to take any questions. And again, thank you very much for having us here. This is truly a great honor, and again, I commend you as a history buff, if nothing else, to take the time and effort, because I can't imagine how complicated this was to put together. So, thank you.
Thank you. Are there any questions?
Yes, Madam Chairperson, Michael Lombardi. Mr. Applesmith, I'm overwhelmed with your presentation, given that 30 years ago, county sheriffs in Riverside and San Diego County were actually raiding Indian bingo halls, and the state was suing us in federal court. Your presence here today stands as a monument to the tremendous and incredible change in relationships between state government and tribal governments here in California. We indeed have made giant leaps through history, and we want to thank you for having come here and reporting to us that the tribes in the state are actually engaged in a constructive, positive, respectful government-to-government relationship in assuring the integrity of Indian gaming. I serve as the chairperson of a Tribal Gaming Commission in Riverside County, Augustine. We've submitted to the Bureau over the last 5 years approximately 1,100 license suitability packets. In that time, the Bureau has only questioned one of them. And as you know, under the compact, the state has the right literally to veto any key management license that we grant. I know you're new in the position and we welcome you, but do you have an idea approximately how often the Bureau has to reject a suitability determination by a tribal gaming commission? As I said, we've had one out of 1,100 over the last 5 years. What kind of percentage record do you believe that the tribes are producing in terms of doing our suitability determinations?
I would say that's fairly representative, but let me also emphasize that it's not that the Bureau is not doing its job to find out whether there are people who are not suitable. It's rather that the tribal gaming commissions are doing their jobs by screening those people out. So by the time, one of the things the Bureau does is we review your processes and to ensure that they are compact compliant. And those processes are, which is a testament to the fact that by the time we get those applications, you've already ruled upon them, and you've already really weeded out the people who should not be involved in the gaming industry, so that you would actually give us someone who we would then find unsuitable is going to be that rare. But that, again, is because the primary regulators are doing their job. Thank you. Welcome.
Mr. Foreman?
I would join Mr. Lombardi in thanking you for being here today and giving your presentation. It's gratifying to hear that. Actually, it was a lot more recent than 30 years ago that Sycuan was raided, as were the other San Diego County tribes at the urging of the Attorney General.
Not this Attorney General, for the record.
No, not this Attorney General, no. The Attorney General then in office, who urged all sheriffs and district attorneys to go out and raid reservations, seize gaming equipment, and arrest those responsible. That was in 1992, I believe. A question, though. Are you familiar with the status of the litigation called Candace Cates versus Bureau of Gambling Control?
That is a case, I believe, that was, there are two parts of it. One part had to do with employment claims against the department, and the other had to do with some sort of key TAM type action that has to do with whether the state was not properly collecting revenues.
Right, and I'm particularly concerned about the latter phase of that lawsuit. Is that lawsuit still ongoing, or has it been concluded?
I believe that lawsuit has been concluded, but I could not tell you for sure. I'd be happy to respond and through email to the commission to make a part of your record, just to give you a status of where it is.
Thank you. And the second question is, a number of years back, the Bureau, I think it was calling itself the division at that time rather than the Bureau, but issued a number of advice memoranda on certain game themes and indicating that certain game themes that the tribes were operating were not permissible. And I wondered, we saw those memoranda, we responded to those memoranda, we never heard from the Bureau again on those memoranda, and I wondered whether those were still live issues or are those in our past?
I'm not sure which ones you mean. The only ones that I know that are at issue are the ones that relate to games that may or may not be roulette, depending on your interpretation of that. That is something that, pursuant to the compacts, we submitted to the governor's office to have the governor's office resolve. So currently, some of those games are being played in tribal casinos in California, and that is something that we are deferring any action on until essentially the governor has determined whether they constitute prohibited games under the compacts.
Thank you.
Mr. Valandra?
Good morning.
Morning.
One of the reasons that, one of the many reasons that the hearing's being held today is that there's been an ongoing questioning by the state of California through the Gambling Control Commission about what is a permissible gambling device under the compact and in relationship to Class 2 under the federal law. I wondered if you are aware of that ongoing inquiry and if you have any comments about that.
Sure, I am aware of that ongoing inquiry. That has really been an inquiry that has come from the California Gambling Control Commission, which is a board that, of course, reports to the governor of California and is set up separately from the Bureau. And we have not been involved in that aspect of the issue with them. The only aspect of Class 2 versus Class 3 machines that we've been involved in have had to do with charitable bingo. And that's not really a Class 2 issue so much, it's more of an issue of straight up, are those machines slot machines within the meaning of the California Constitution? And we've said that they are. And so we have essentially taken law enforcement action to stop those machines in various charitable gambling halls. We have been enjoined by a federal judge for the time being under a variety of legal theories really having to do with the Americans with Disability Act. But it's quite clear to us that those machines are illegal under California law, and we're just waiting for the federal judge to tell us that we're no longer prohibited from enforcing that law. Because there certainly are, in our view, illegal slot machines in the state of California, illegal because they're not in your casinos.
Okay, thank you.
Any other questions? Thank you.
Thank you very much. Have a good morning and good luck for the rest of your time.
Thank you.
I would like to now introduce the former Lieutenant Governor of the State of California, the Honorable Cruz Bustamante.
Good afternoon.
Good afternoon.
Bingo and Class 2 gaming is the foundation upon which tribes build gaming. bingo and Class II gaming was allowed by the federal government. The state of California already had bingo and Class II lottery games, so the state couldn't deny Class II gaming to tribal governments. Any attempt by a state commission to take away Class II gaming flies in the face of federal law, tribal sovereignty, and state legislative intent. Let me offer you a historical perspective of that legislative intent. Perspective that I am intimate with because I was the Speaker of the Assembly during that legislative debate. During 1997, then Senate Pro Tem Bill Lockyer carried a bill in behalf of Attorney General Dan Lundgren, which attempted to place tribal gaming under the jurisdiction of the State Gaming Commission. I was called to a hearing room after a group of tribal advocates and leaders protested the bill. I immediately shut down the hearing and asked the author to meet with me and the tribal leaders. After several hours of discussion, the author did not offer to make any changes to the bill despite the best efforts of the tribal leaders. Chairman, Danny Tucker, was there at that time. I think he remembers very specifically what took place that evening, because it was in a moment of frustration in which another tribal leader, Marianne Andreas, then the chair of Morongo, said, if it is a decision between tribal sovereignty and gaming, I choose sovereignty. All the leaders agreed. And in that midnight declaration, the Assembly stripped out all references to tribal gaming being under the jurisdiction of the State Commission. That night set the precedent that the California legislature would honor tribal sovereignty. That night set the precedent that the state of California must sit down with tribes and agree on how gaming should be conducted in Indian country. That night set the precedent that the State Gaming Commission could never unilaterally make decisions that affected tribal gaming. On the day after the gaming initiative passed, I asked a group of tribal leaders a question. Does the passage of the initiative guarantee tribal gaming? The answer to that was and still is no. But it does give tribes the right to fight for gaming every day for the rest of our lives. There are many battles. You have to pick your battles. But this is not just another battle. This is a basic right, a basic fight for tribal sovereignty. If a state commission can take away Class II gaming, then what is the limit of their authority? Can they take away other types of gaming? Can they expand gaming to other? Just set a policy as one set of rules for everybody. They should ask California corporations who pay 8.5% corporate tax the same as tribes pay, a 25% tax. There shouldn't be one set of rules for IBM, Microsoft, and Walmart, corporations whose headquarters are not in California and have another set of rules for California's tribal governments. Make sure that you're not confused by the facts here. One touch, two touch, those are just details to leverage an argument. An argument, if allowed, is designed to take away the right of your sovereignty. Thank you for allowing me to be here and share my thoughts. Be more than happy to answer any questions.
Madam Chairperson, if I might be permitted, wonderful to see you here, Cruz. As you know, you're among friends. If we could just have you expand a little bit on that most illuminating history about how the Gambling Control Act, my recollection was that the author at that time was, I believe, the Speaker Pro Tem of the Senate, Mr. Lockyer. We've come a long way since the passage of that act. Could you talk a little bit about the architecture of the state gaming agency? As you know, Lieutenant Governor, I always think of you as a Lieutenant Governor. The decision was made to create a state gaming agency that is composed of the California Gambling Control Commission, and now we know it as the Bureau of Gambling Control. What do you recall in your mind as to the history of why the state decided to model their gaming commission after the New Jersey model and create two agencies, as opposed to how it happens in Nevada, where they have the Nevada Gaming Control Board? You share those historical memories with us?
Very generically, I mean, during the time that I was in the legislature, it seemed like tribal gaming began and blossomed and fully developed between 1993 and 2006. And during that time, it initially started in which the issue was whether or not card clubs, racetracks, and tribes were going to share in this activity called gaming. Then it was gambling. It's been upgraded to gaming now. And in that time frame, the question was who was going to get what and who had more power. And through that process of going through trying to figure out this process, the racetracks and the card clubs felt that this stepchild, tribal governments, really didn't have a seat at the table and wouldn't allow them to sit at the table to discuss how this entity could be constructed. It was only through the initiative process that tribes went to the people, that the people decided to give tribes an opportunity to game and gave a certain protocol and regulations under which they could operate generally. Then this legislation that was brought up by Lockyer attempted to construct this activity, this gaming commission that would have oversight over all gaming. It was felt at the time that having one entity that would be in charge of all gaming would take the compacting process and not give it its true, and it would not reflect a true compacting process. It would basically put tribes under the thumb of the state rather than acting as peers, rather than acting as negotiators on behalf of tribal lands and the state acting as a negotiator in its behalf. Having equal say, having to make the process come to consensus before agreement could take place. The process was interrupted because the legislature wanted to make sure that in fact the promise that had been given by the voters was that tribes would have an equal footing in deciding their fate. And so any commission that comes to you now and says that somehow they have the authority, if you give them that authority, they will have it. But because of legislative intent and that which is already clearly stated in the records of the legislature, they clearly do not. The intent clearly by the legislature is that tribes, Indian country, can determine their own fate. They can decide to allow the state to come on tribal lands. They can decide to take certain games on and off. Tribal governments can decide to do that, but no commission, no agency can unilaterally do that to Indian country unless you allow them to. So I would hope that the issue moves away from a skirmish of whether or not Class 2 gaming is one touch or two touch. That don't be, as I said earlier, don't be confused by the facts, because people will create and craft arguments to put people in boxes and put them in corners to make it seem as if somehow one thing is being done, and if you're doing something, then it must not be what was the original intent. That has nothing to do with your ability to make a decision on your own fate. You decide. That was the intent of the legislature. I was there. I am witness to that. So, at this point, as you look at the way that things are constructed, do not give them the kind of authority that they just do not have.
Any other questions?
Yes, I have a question. It's a bit theoretical, I think, but I think it'll be helpful for us to to have your perspective on this, and I'll take just a second to lay out
Sure.
out the premise of it. Given the structure of the relationship between the state of California and the Sycuan Nation or any other tribal nation that has a compact with the state, there's a complicated relationship both on the regulatory side and on the financial side. And in essence, the dependence of the state on the economic side sometimes drives issues on the regulatory side. I guess what I mean by that is that there's a certain expectation set by the state of California through the governor or other agencies that a certain amount of income is expected to be generated by the financial relationship in the compacts. I'm wondering, from your point of view, how much of that drives the regulatory issues that, or the perspective of, say, the California Gambling Control Commission or others of that ilk? From your point of view, what is the interplay between those two relationships, if any?
Well, for anybody to say that during a bad economic period people aren't looking for new revenues is either a liar or a fool. Every organization, whether it's in Indian country or in government or in business, they always look to try to find additional revenues out of necessity. So I don't believe that that's the full matter in this particular case, but it has to be something that must take it into account. I mean, that has to be one of the motivating factors. The government itself has to figure out ways of being able to provide for all of its citizens. There are very, very difficult decisions that are made every day about whether or not kids are going to go to class for 180 days. Seniors are going to get medical attention. People on the street are going to get fed. Having enough swine flu vaccinations, making sure that people on AIDS are being taken care of. You can go through all the many, many, many complications and challenges that a state would have. And it has to be aggressive in its efforts to be able to provide for all those needs. And so it's a natural thing for people to come and try to find revenues. But if you recall, there was a little election a few years back, a recall election, I believe. I'm not real familiar with it. I can't recall the details of it, but I remember that there was this one candidate who indicated that they were going to make sure that Indian country paid their fair share. I'm not sure I ever found out what that meant, but maybe he's still trying to make Indian country pay their fair share.
I understand your answer. Thank you.
Any other questions? Thank you.
Thank you.
Governor Bustamante. That completes our morning session. We will now break for lunch and reconvene at 1:30.